All right, ladies and gentlemen, tonight we're going to go ahead and do our cumulative course review. I want to be able to go over everything we talked about this semester, kind of in a nutshell. It won't be something that's too overarching. But we'll talk about kind of review everything we've gone over this semester. So I'll be going kind of through the book and just talking briefly about every chapter and what we talked about. Of course, going to go through the textbook, criminal courts, structure, process, and issues. Dean Champion, Richard Hartley, and Gary Rabe. That is the textbook. This is the third edition of the textbook that I use for my lectures from time to time. So, we started out with chapter 1, where we talked about the legal battlefield. That's pretty much where we talked about the structure of the court system, which is really what this class is about, teaching the structure of the court system and the players in the game of the court system. So there are very important people in the court system who have jobs that help progress and move cases along. So we talked about what is law, the difference between criminal law and, of course, civil law. So we talked about the types of law, substantive law, which is the law that defines what is and is not illegal for us as individuals walking around, what I can and cannot do, and also what the penalties are if I walk outside those prescribed lines. Then we talked about procedural law. Procedural law is pretty much the rules that govern how the system treats us when we're accused. Notice I said accused of stepping outside those bounds of substantive law. So if we're accused of breaking a substantive law, then there are going to be rules that apply to how the systems are going to treat us. That's procedural. Then we talked about what the common law means. Of course, that's old law that has kind of come over as a matter of culture and a matter of just bringing law over and putting it on the books from England, Great Britain. We talked about civil law versus criminal law. I believe we talked about civil being a personal interest versus another personal interest. I'm suing you because you owe me money or you did me wrong. I want the value of that back. I want the court to either stop you from doing something or force you to pay me. As opposed to criminal law, where in criminal law you have violated that code of ethics, that code between you as an individual and everyone else in society. So when you're brought to court for some type of criminal violation or infraction, you're accused of violating the code of conduct that all of us are supposed to follow. So there's this invisible contract that we, as a part of being a part of society, we've agreed to adhere to. So when we fail to adhere to that, we're now brought into criminal court to face a trial in front of the society itself. In other words, we're brought there to show cause as to why we violated the law or defend ourselves and say we didn't violate the law. So that's what criminal law is: criminal versus civil. Of course, we talked about the burdens of proof, criminal law, because of course you're being brought before society because you're alleged to have violated a law, so you're facing possible loss of freedom, or depending on what you're charged with, loss of life. So therefore, the burden of proof is much higher. So the burden of proof in criminal law is beyond a reasonable doubt, which in North Carolina jury instructions describe beyond a reasonable doubt as the jury being fully satisfied and entirely convinced of one's guilt. So those are unequivocal words, right? Fully and entirely. So if and we give a little bit of a margin for error. So if I was to describe mathematically what beyond reasonable doubt means, that means that a jury must be like 99.9% certain of one's guilt. Now, on the other hand, we have civil law. In civil court, the burden of proof is much lower because it's all about property and all about essentially money. So you want some type of a judgment, or you want the judge to enjoin another party from doing something. So in civil court, because there's not life and limb or life and freedom on the line, the burden of proof is much lower. It is what we call by preponderance of the evidence, or what we call more likely than not. So if we were to describe that mathematically, it would essentially be 51 to 49. If we had a pie, instead of cutting it right down the middle, 50-50, 50-50 is not by preponderance of the evidence. So if a person proves the case 50-50, that person is not civilly liable, or that's what we call guilt in civil court, liability. That person is not civilly liable because it has to be more likely than not. So not down the middle, but a little bit more. So 51 to 49 to prove liability, or what we call civil guilt or liability. So that was chapter 1. Chapter 2, that's when we talked about more about the structure of court. In the federal court, starting from magistrate and trial courts, working our way up the hierarchy to the district and magistrate trial courts, up to the courts of appeals for each circuit. We learned that North Carolina is in the Fourth Circuit, so that would be a good thing to know. North Carolina is in the Fourth Circuit of the federal court system. So that means when North Carolina cases from trial court, if you want to appeal them, you're going to go to the Fourth Circuit Court of Appeals. From there, if you appeal again and you don't like that, it goes up. The court of last resort on the federal and actually state side, when it comes to if it's a federal issue, is the United States Supreme Court. So that is the ultimate court of last resort. And on the federal side, it's definitely the court of last resort. But even in some state cases, if it is a constitutional, U.S. constitutional or federal issue, even though it may stem from a state jurisdictional court, if it is a matter of constitutionality, sometimes if the Supreme Court chooses to hear that case, state court cases can be appealed all the way to the United States Supreme Court. A lot of times, especially in criminal procedural law, a lot of those cases started out in the state court. Terry v. Ohio, cases like that, they started out in state courts, and they worked their way up. And because it was a matter of constitutionality, the Supreme Court heard the case and rendered a decision. Talked about state courts; they have a similar hierarchy depending upon where you are. You always have your trial level courts. From your trial level courts, you can appeal to or either appeal, or depending on if it's an indictment state, and you're charged with a certain case that has to be indicted, like a felony. You may have your district court, which is your misdemeanors, like in North Carolina. District courts in North Carolina have original jurisdiction over misdemeanors. So for a misdemeanor to go up to the next level, which is superior court, either it has to be appealed after a trial. That means a defendant would have had to have lost a criminal trial in district court, and they want to appeal, in which they get a trial de novo or new trial in superior court, where they would get a jury trial, or it can be indicted. So superior court does have original jurisdiction over felonies. So district court in North Carolina has no jurisdiction over felonies. So any felony that's disposed of in district court has to be reduced to a misdemeanor before a judgment can be rendered. So district court in North Carolina, misdemeanors, traffic and misdemeanor. We move up to superior court, either by appeal and trial de novo, or either it's a felony where district court wouldn't have jurisdiction anyway, or it's a misdemeanor that's been indicted. And usually when that happens, that's because the misdemeanor is with other felonies, and the felonies get indicted, so they bring the misdemeanor up for trial as well. So that's superior court. So both district and superior court, those are trial courts. From there, cases can be appealed, and then they go to the North Carolina Court of Appeals. So North Carolina Court of Appeals, that's like the middle step. Then from there, if a person doesn't get what they want, they can then appeal to the North Carolina Supreme Court. So state Supreme Courts are the courts of last resort in states. Now, like I said before, depending on what the issue is in that case, sometimes a case can be appealed from a state Supreme Court and go federal and go to the the ultimate court of last resort, the Supreme Court of the United States, if it is a some type of either federal question or usually a constitutional question that needs to be answered. So that is the structure of the courts. Then chapter 3, we talked about the prosecution and the adversarial criminal justice system. We talked about the rights and responsibilities of the prosecutor, how they do have a very wide-ranging, what would I call it, prosecutorial discretion. So they have a lot of discretion in making decisions on what to prosecute. They also have a job to do. They have to essentially screen cases and prioritize what they're going to prosecute and how they're going to prosecute it. And so they create the structure of what happens in court in criminal court, because they decide what's going to get prosecuted or not. So a lot of times defense attorneys, we govern ourselves by the rules of the prosecutor, because they essentially run court. So what they're going to prosecute and what they're not going to prosecute, we have to govern ourselves accordingly. Because that's one thing about court. When court, even if it's the defense attorneys, if we don't necessarily like the rules or like what's going on, if we know them and we know there's a process and there's a procedure for everything because the prosecutor has set this in place, at least court is predictable. We're better attorneys when we can tell our clients what's probably going to happen. We can give them a probability or kind of predict what's going to happen in their case and how the district attorney is going to prosecute it. It also allows us to be better negotiators, because we kind of know what the DA wants, and sometimes as a negotiator, I have to negotiate things in a manner where I can get as much as I can from my client while also leaving the prosecutor in the situation where they feel like they haven't been robbed, or they got something out of it, or they got a chunk of meat, a chunk of flesh out of my client. So we talked about roles of prosecutors, what their job entitled. We talked about prosecutorial misconduct. Of course, that's we talk about malicious prosecution, and that's where if there's a situation where it's obvious that a person's not guilty, and or there's evidence to show that this person didn't do something, but they proceed and prosecute this person anyway, that is malicious prosecution. Also talked about other things. Of course, they do have discretion as to what to prosecute and what not to prosecute. So we also talked about the sanctions if they are found to have committed some type of misconduct. So just like regular lawyers, they can be disbarred and they can be sanctioned. Then chapter 4, we jump to the defense. Talked about legal ethics and professional responsibility. What as a defense attorney, what my number one job is when I have a client. Of course, I'm duty bound to hold their confidences. So that there's attorney-client privilege, which essentially keeps me from ever having to divulge anything my client says. Unless, and if I do choose to do it, there's certain reasons I can divulge it, but I usually cannot be forced to divulge anything that my client tells me. So what that means, it has to be something that my client tells me and me alone as an attorney. So can't have once you have a third party that's outside of that attorney-client relationship, then that confidentiality is already broken. So a lot of times I ask my clients, even their parents aren't a part of the confidentiality. So if I represent a 18-year-old kid, and their mom is probably paying for my services, but when it's time for me to talk, if I really want it to be a conversation held in confidence, I'll ask the parent to sit out in the waiting room, and I'll just talk to the person, because even though the parent is paying me to represent their 18-year-old, the 18-year-old is actually my client. So that's how that works. Sometimes we have to do whatever we have to do to protect that confidentiality and that privilege. So we talked about things that the defense attorney is duty bound to do. Of course, we want to zealously represent our clients, but we want to do it ethically. We have to create or formulate defenses for our client, or what we call case theories of the case. So our client comes in, they have a story. Sometimes they did it, and what you'll learn is doing it doesn't necessarily mean that you're guilty. Guilty is a legal word. It's legal verbiage, and it means something. That means you've been found legally responsible for a crime. And you can be found legally responsible for a crime even if you didn't do it. So there's a difference between doing something which is factual, yes, I did that, versus being found guilty for it. There are a lot of people who did it, but they're not guilty, if you know what I mean. So there are people who took an action that caused a harm, but depending on what the defense theory is in defending them, they might have been justified. If they were justified, even though they did it, yes, they pulled the trigger and they shot that person. If they did it in self-defense, that is a defense, and they may be justified. So they did it, but it might be a situation where they're not guilty, because doing something factually versus being guilty of something are two different things. Normally, in a just society, a person that did do something usually is going to be found legally guilty. Um, but in some situations they're not, because they may be justified. So we talked about some of those criminal defense theories. We talked about insanity or automatism. So essentially, if I am insane and I'm out of my head, I don't know what I'm doing, I'm not necessarily justified in what I did, but I'm excused. So that's what we call excuses. You may be excused from your actions because you may legally be deemed to be in a situation where you can't control your actions, or you don't know right from wrong. Um, Talked about intoxication, also kind of falling into that insanity situation where because of whether I intoxicated myself or I was drugged. Depending on, and it makes a difference whether it's self intoxication or voluntary intoxication versus involuntary intoxication. Because of course you're going to be allowed to use involuntary intoxication way more. That means someone drugged you. You're going to be able to use that as more of an excuse than being voluntary intoxicated. So if I'm drinking on my own and I get drunk and I do something, I'm not going to be as covered and protected by law as I would be if it was involuntary intoxication. So there are some defenses. I can use that as a defense to certain things, voluntary intoxication, but not everything. So you're more limited when it's voluntary intoxication. Talked about coercion, duress, doing things out of necessity, essentially having to commit this crime or do this thing um, out of necessity because you had a set of bad choices. Either you stay there, remain in harm, or someone else is in harm, or you get behind the wheel anyway and take off even though you're drunk because you're getting shot at. So do I stay there and get shot at, which is a greater harm, or get killed, or to get away and to be safe? Do I get behind the wheel even though I know I'm super drunk? So sometimes you can also use necessity as a defense. So I did something to prevent a greater harm out of necessity. Um, Alibi. I wasn't there. Somebody else did it. Entrapment. The government essentially set me up. I wasn't about to commit this crime. I was minding my own business, and they walked up and said, "Hey, commit this crime." As soon as I did it, they said, "Okay, yeah, we're the government, and we're arresting you." It's like, well, I was chilling. So that's what we call entrapment. Self defense, of course, being not an excuse, but that is actually a justification. There's a difference between justification and excuses. A justification is when you say, yes, I did it, but I didn't know I did it. I didn't have the sense to know better because of insanity or whatever's going on. Justification, however, says, yes, I did it, but I was justified in my actions because of the situation. Either I did it out of necessity, which is justification. I did it out of self-defense, defense of someone else. Um, those are justifications. So there's a difference between a justification and an excuse. So those are just the defenses, the things we have to formulate to help our clients. So our clients come in and talk to us. We have to figure out what is their story, what is the story we're trying to tell in negotiations, because I want to know as much about what happened as possible, because that also helps me when it comes time to bargain and to talk to the DA about what's going on. Because if I can develop a defense, if I can push this out in front and let the DA know, hey, this is, the probability of you winning the trial is very low because we have this evidence, this person, this looks like this is what my client's saying happened, and the evidence says doesn't contradict it. So it may help me keep my client from even having to go through the peril of trial. Maybe I can get a case dismissed without my client having to go through the trial process, because a trial is a risk. You can either with two things that happen at trial: you win or you lose. So yeah, you can roll the dice and win. Yes, we go home. Um, But if I can keep you from ever having to roll the dice and guarantee a victory without us rolling the dice, then that's better. If you know you can win without gambling, it's almost like you're playing with somebody else's money, right? So you know either way it goes, you don't lose. If I can control the outcome as much as possible with my client, I do that. So I have to prepare, and kind of being my own investigator in my client's cases, figure out what happened, figure out there's something I can use that's gonna be exculpatory, meaning take them out of guilt. Culpatory meaning guilt. So exculpatory, out of guilt. That means something that's helping prove my client is not guilty, as opposed to inculpatory, which is in guilt. So we look for that type of evidence. We try to help our clients out. Another person is very important. Chapter 5, and we talk about judges. Judges are like the person in the middle. They the number one job of a judge is to, first and foremost, at least at the trial part of portion of court, is they're there to determine matters of law and matters of evidence, like what gets in. They apply the rules of evidence. We enter evidence in by way of witnesses, and so we're really, physical evidence only gets in if it's testified to anyway. So you got to have witnesses, you've got to have the evidence, and we're trying to get it in to tell our story. We use evidence, witnesses, and evidence to tell the story we're trying to tell for our clients. And the prosecution does the same thing. They use evidence, and they use witnesses and evidence to tell whatever story they're trying to tell, and they're opposing stories. But the judge sits in the middle, and the judge determines what evidence and what testimony gets in and what doesn't get in. That means they're determining matters of law and evidence first. That's the judge's number one job, especially at trial. Sometimes cases don't go to trial, right? Sometimes we plead guilty. There's some type of a deal, and then the judge sits in the middle again, and they have the duty of either accepting, if they feel like they want to accept the deal that we've made between both parties, or they can say, I don't accept it, take it somewhere else. So they can accept plea bargain, and then once they accept a plea deal, then their job is to punish. That they render, not punish, but use a better word. They render a judgment and determine what the punishment is going to be. So the judge does that. But once we get to trial, depending on what type of trial it is, so in certain jurisdictions, North Carolina and district court, the trials are what we call bench trials. That means the judge is in there not just determining matters of evidence and law, but if we're going to go to trial, we're going to trial, and now the judge is also the jury. So they've now become 12 people in one person, and they have to determine guilt or innocence in a trial. So that's another thing sometimes we ask judges to do. In the superior court level, in certain jurisdictions that have only jury trials, the trial in those type of trials, jury trials, the judge does not determine facts. They're not the trier of fact. They stick to the gun. They stick to just determining matters of evidence and law, and they let the jury determine guilt or innocence and what happened. So that's judges. We talk about how judges are elected. In some states, it is partisan politics. Other states like North Carolina, it technically isn't, even though it really is. Technically, it's not partisan. But when a person's running, you kind of know what political affiliation they have when they're running. So I talk a lot about judges because I was actually in the running to be a judge at one time, to be appointed. So I learned a lot about the job, stuff that I never paid attention to before I did that. And I learned, like, wow, it's very political, and there's really a lot of room to be compromised professionally, because you're a judge, you got elected or you got appointed, and you get appointed under some type of political what would I say, political stance. So it's almost like a politician that makes promises. So once they get into office, now even they're in a situation where they gotta kind of follow those promises. I said I was gonna be this type of person. Now I have to be this type of person. And I think as a judge, that takes the fairness out, because every case that comes in front of you, even though it may be the same type of facts, every case is different. You have to treat it as being different, and you can't really be robotic. If you're robotic and you say this is who I'm going to be, I see that as being compromised. If you can't look at every case on its own merit and not factor in what you bring in, so you kind of have to come in with a clean slate, and that's kind of humanly impossible. We say we can do it, but I don't know. So I've always kind of questioned that. And of course, being political, that means you probably owe some favors to someone that helped you get into office. And now you're kind of compromised. And it just is what it is. But we can't get around it because even if it was lifetime appointments, you're still getting appointed by someone that was elected. So either way it goes, you can't get around it. We just have to try our best not to be compromised and to make the right legal decisions, regardless of who put us in office or who's in front of us at the time. We have judges have to take every case on a case-by-case basis. Now, Chapter 6, we talked about juries. The history of juries, two types of juries. There's the grand jury, which does not determine guilt or innocence at a trial, but they do determine what cases are going to be indicted. So there's a formal presentation of the evidence, and that presentation is from the prosecution, and the prosecution only. There's no opposing side, so it means it's ex parte. They get to put on all their evidence. There are no rules of evidence. There are no rules governing what they can present in the grand jury setting. They present it. Once they present it, the grand jury can use everything they said. The kitchen sink, Ned the wino can come in and testify, and at that point, the grand jury will convene and determine whether or not they're going to grant a true bill. The true bill is what we call an indictment. True bill of indictment, which says yes, there's enough evidence here for you to move on. We're not saying the person's guilty or not guilty, but we are saying there's enough evidence for you to take this thing to trial if you see fit, Mr. or Mrs. Prosecutor. So that's the grand jury. Then you have what we call a petite jury, but we usually leave the petite off and we just call it the jury. Those are what we call trial juries, juries that determine guilt or innocence in trials. So that means that the cases from both sides are presented to them, and they have to sit there, go vote, deliberate, and come back out. In most states, it has to be unanimous. And North Carolina is unanimous. So that means if in North Carolina we have a 12 juries impaneled and 2 alternates. Once we get to the end of trial, if we find out we don't need the alternates because all 12 juries stayed or didn't have to be excused for any reason, then those 2 alternates are taken. They get to go home, and then the 12 people get to determine guilt or innocence. They meet, they deliberate, and they come out either saying, all 12 of us unanimously found this person not guilty or guilty. So it has to be unanimous either way. If they can't come to a unanimous decision, then at that point, that's what we call a hung jury. At that point, that sometimes is a win. I count as a defense attorney. I count it as a win because the prosecution has the job of proving guilt beyond a reasonable doubt, unanimously to a jury. Anything short of that means they didn't do it. They didn't do what they said, what they promised they were going to do. They didn't meet their burden. So in that situation, they can always go to trial again. But for the most part, usually that is counted as kind of a loss. That means I couldn't prove my case beyond a reasonable doubt to a unanimous body of 12 jurors. So because they couldn't do that, then of course as a defense attorney, I'm like, hey, you had one job and it didn't happen. It'd be better if you didn't choose to try to put yourself through this again and waste the resources of the state. Sometimes they do. The Bill Cosby case, that had a hung jury in the first trial, and instead of dropping it or reducing it or making a deal and getting up out of there, they said, "Nah, we're gonna go to trial again," and they went to trial again. And the second time they won. I believe, I have a lot of opinions about that. I believe that second trial at this point, now you got jurors that have watched the first trial and see what happened. So I think it might have been kind of tainted, which you can never kind of not have a perfectly untainted jury that acts, perfectly unbiased in the situation. It just, it's just part of the game. But yeah, the jury size differs from state to state. North Carolina is 12, and sometimes maybe 2 or more alternates. So jury size can change. Of course, when we determine how do we select jurors, the jury selection process, we have what they call a voir dire. Voir dire means to tell the truth. It's like a French word, a French phrase. But it means to tell the truth. It means there's a back and forth individual questioning setting where we ask these people questions, all 12 of them. And, we take people down if we don't like them. And each side, the defense and the prosecution, we have a certain number of strikes per side. So as the defense attorney, I get 6 um, preemptory strikes. Preemptory means for no reason whatsoever. I don't have to explain myself. I just don't like that person. Me and my client talk. My client doesn't want that person on the jury, so I move to strike that person. The prosecution has the same sits, right? We have an unlimited number of challenges or strikes for cause. That means in this voir dire, in this questioning, this potential jury has given us an answer that has essentially said they can't do the job. So if we're saying, can you be fair and impartial, and they give an answer that lets us know they can't, then in that situation we have no choice, because they have one job to do, and they've essentially said for personal reasons or religious reasons or whatever they're not going to be able to do it. That means we have to strike them for cause. They have to come down. And they have to be replaced. So after this back and forth, you sometimes jury selection may be the most important thing that happens in a jury trial. Because you have to impanel the people, and it is, I hate to say it, it is kind of a popularity contest. You have to, that's why you ask people personal things about life experience, because you want to kind of know, you kind of want to profile them and know what their thinking is. So if you have a client that acted a certain way or did something that he or she feels is justified based upon some type of logic, you want to have people on that jury that may understand and come from a background where they may understand that logic. So you have those strikes to go back and forth, and when it's all said and done, when the dust clears, we have our jury impaneled. Now, of course, during this strike process, this process of voir dire and striking jurors, either preemptory or for cause, it can never be based on anything racial or ethnic. So I can't. And this is specifically for the prosecutor. The prosecutor can't try to have an all-white jury just because he doesn't want any black people on the jury. Now, sometimes all-white jurors do happen. Normally, the court doesn't like that because it's Captain Obvious. There's 12 white people in the box, and there's a history behind that. So they would rather have cultural and racial diversity on juries. But sometimes, depending on the I guess the population of the jurisdiction you're in, sometimes it is what it is. If you live in a county where it's mostly white people, you might get an all white jury. So it happens. We like for it not to happen, but the thing is, the prosecutor in general, particularly the prosecutor, because they represent the people, the interests of the people, they definitely can't be racist or do anything based upon some type of racial or ethnic bias when they're picking juries. Now, on the other hand, the defense attorney, it is frowned upon. We're not supposed to do it, but at the end of the day, as a defense attorney, I'm not there for everybody. I'm there to get a jury that is going to relate to my client. If my client is a black male, you bet your bottom dollar I would like all black male jury. People that might have walked in his shoes and understand what it is to see things to the eyes of a black male in America, right? Or a white, or even a white male. If I have a white male that's involved in some type of crime, and because some crimes, I hate to say it, are you can almost kind of guess who committed the crime based upon the crime itself, right? So we're looking at something, and some type of white collar crime, or a situation where, let's say, it may be a situation where there may be insider trading, stocks and bonds. Now, they're not saying there are no black people in, securities exchange, and people that not there are no black people that have their securities and exchange license. But for the most part, that is a primarily white male driven area. So a lot of times, if someone's accused of violating a law, you can almost say, bet you's a white male. So if that's who my client is, I may want white males that understand why he did what he did, or they may be able to see it his way. And sometimes it depends. So for me as a defense attorney, um, I only represent one person. I don't represent everyone like the prosecutor does. Should me picking the jury be based upon racial bias? It shouldn't, but can it be? Yes. because I only have one person I care about. I don't care about everyone's rights when I'm in this trial. I care about this defendant that I'm hired to represent or appointed to represent, and I can only care about this one person right now in this snapshot in time. So, yeah, sometimes as a defense attorney, we are biased. We know who we want on the jury. So it is what it is. So that's the jury selection process. During the trial process, of course, both sides go. Evidence is presented. Then the jurors are asked to, sometimes they're sequestered or kind of cordoned off and said, cut your TVs off, go in there and make a decision. When you go home, don't do this, do that. You're going to make a decision not based on what you heard on CNN, but what you heard in court. And that's one thing a lot of times, because in the court of public opinion, and we'll talk about this in later chapters when we talk about the media explosion in courts, but in the court of public opinion, you have these pundits and these talking heads on these networks that are saying, "Hey, this person's guilty. They did that and did that," but they don't know the evidence, and there's no judge that is there to determine what they can and can't look at, and what comes in and what doesn't come in when they give their opinion or when they formulate their opinion. On the other hand, a jury, they're locked in because the court can limit what what they're gonna be able to take in the room with them, what they're gonna be able to hear, and what's gonna be able to come into evidence. So because of that, there are rules of evidence that apply, and there's certain things that the talking heads, the pundits, and the people with opinions can say on TV that may not have anything to do. A matter of fact, whatever they're basing it on may not even be relevant at trial, may not even get in. So sometimes that's why sometimes there's such a difference between the court of public opinion and what we're talking about in the streets, as opposed to what happens at trial. Because of course at trial there are rules that limit certain things. And there's a whole thick book of rules, the rules of evidence. So you have federal rules of evidence, and most states usually coincide with the federal rules. They might have a change here or there, but the evidence code anywhere you go is thick. There's a lot of rules that determine what gets in and what doesn't get in, and we're not here in this class to explain that. But a jury can sometimes make a different decision than what we think is going to happen in public because they have a different set of rules that they have to adhere to. So they go in and they have to render a verdict. Can the jury ignore the law, even in a situation where it looks like a person's guilty? Can a jury say, "Hey, the law says this person did it, but we want to let this person go. We like them." Yes, they can do that. Now, they can't ignore the law and convict someone, but they can ignore the law and set a person free. That is what we call jury nullification. So a jury can be nullified, and sometimes I've actually had a jury nullification argument in certain trials. Like, hey, my client could have made better decisions, but he was right. And I challenge you guys to put, well, you can not ever tell a jury to put themselves in a situation, but I want you to look at it in a certain way. He did this because his mother was disrespected. He wanted to protect his family, the honor of his family, and he made that decision. Was it the perfect decision? If he, no, it wasn't. If he'd made a different decision, we wouldn't be here today. But he was right. So in certain, this person may not be legally right, but I've just argued to the jury that even though he's not legally right, you should still let him go and ignore the law because he's a likable person and he's a just and honest person that just made this decision. So, a jury can be nullified, but it can only be nullified in favor of the defendant, letting the defendant go. They can never ignore the law when it comes to convicting someone. Juror misconduct, of course, they can't take bribes and be paid off and stuff like that. We talked about then chapter 7, pre-trial procedures and the trial process. Of course, you're booked, you're arrested, an initial bail or bond is set. And bail or bond, those two words are used interchangeably, but that's all about determining what the collateral is going to be for this person's release. So bail is not about punishing a person for what they're alleged to have done. The only reason what they're alleged to have done is even considered is because depending on how serious the crime is that they're alleged to have committed, sometimes if it's a very serious crime, that also means that this person, if we let them walk out, they have more incentive not to come back because this is murder. If they go to trial and they're found guilty, they'll go to jail for life or be sentenced to death. So maybe we should jack the bond up or not give them the opportunity to get out at all. Because if they get out, the logical thing to do would probably be to run. It wouldn't be the just thing to do, but we would understand it if they ran and went to left the country and went somewhere where they couldn't be extradited. Um, bail is set and bonds are set to determine um, what the collateral is going to be that's going to be held against this person if they don't come back to court. So it's all about securing a person's presence in court. It's not about punishing them at all. So bonds or bails are not punitive. They're about determining. So in other words, if I put $100,000 up for my release, that means if I don't come back, I'm gonna give up that $100,000. If I want my $100,000 back, I need to come to court. Now, whether I'm guilty or not, at the end of it, I'm still entitled to get my $100,000 if I put it up. We also talked about the types of bails. So you have secured bonds or bails, unsecured bonds or bails. Secured means that the collateral must be provided, but it can be provided by a third party called a bail bondsman. So that person can come in and say, I'm going to be responsible for the entire bond. So if it's $100,000, they'll say, hey, I'll be on the hook for it. In return, I'll get this person out of jail, and it'll be my responsibility to make sure they make it back. If they don't, then I'm on the hook. And in return, instead of this person now having to pay a full $100,000 to get out, a lot of times bail bondsmen will charge anywhere from 10 to 15%. So that turns a $100,000 bond to $10,000 for that person to get out of jail. Now it's non-refundable because they're paying 10% of what they were supposed to pay to a third party. But that's how bondsmen make money. Now, the minute that person skips and doesn't come to court, now that bondsman is on the hook. And that's why you have people like Dog the Bounty Hunter. They want to go out and find that person within a certain amount of time, so they won't be on the hook for that money. That's secured bond. An unsecured bond is when the collateral is determined, but you're still released and you don't have to pay the collateral up front. And so if you ever miss court, that bond can be forfeited. And that means now you owe us that bond because you didn't come to court, but you didn't have to pay it up front. That's unsecured. Then you have cash, what we call cash bonds. That means with a cash bond, you can't get a bondsman. Either you have to have it all or you don't. And a lot of times they use those in child support cases because once they collect the cash, they can order that it go to the payment of the child support. So that's pre-trial. Then you have preliminary hearings. You have grand jury action, arraignments. When a person is brought before the court and asked whether or not how they plead guilty or not guilty. Then you have your trial. You start the trial process. Sometimes they're pre-trial motions. You make those motions, and this is done outside the presence of a jury when they're talking about matters of law. Once that's all said and done, then if the case goes forward to trial at that point, then we bring the jury in. We select the jury. We impanel the jury. Then we start the trial. We start the trial with opening arguments. Both sides get to go. Prosecution opens first with their statements, opening statements, and then the defense goes and they do their opening statement. Then the prosecution, they have the burden of proof, so that means they have to present evidence. The defense doesn't have to present anything, but the prosecution definitely has to put on some evidence. If they don't have any evidence or witnesses or testimony to put on, that means there's no case, and while we here, dismiss the case. So they have to put it on. Now, in response to them putting on their evidence in their case in chief, that's what it's called. Of course, every witness they put up also is going to get cross-examined by the opposing side. That's the Sixth Amendment right of both sides. Any witness is called up by either side is subject to be cross-examined by the opposing side. So while they're putting on their case, the opposing side gets to cross-examine. Then once the prosecution is done with their case, then the defendant and his counsel can decide whether they even want to put on any evidence. I've had cases, and I won a trial where we actually didn't put on any evidence. Me and my client looked at each other and said, wow, their case is really terrible. I think their case is so terrible, we can win this without you saying anything. We're just going to shut up, and then we're going to be the last voice that's heard at the end. So there was also an advantage we gained, a strategic advantage we gained in not saying anything because we got to be the last voice. So, but in certain situations when we do decide to put on evidence, then it's our case in chief. It now shifts to us to put on evidence and witnesses. We do that. All our witnesses are subject to cross-examination while we're questioning them. Then once we're done, it's close of all evidence. Sometimes the prosecution can offer a rebuttal case, bring another witness. They can open back up and bring people in. Sometimes it can flip-flop for a while. But at the close of everything, once all is done, then everyone then both sides get to give a summation or a closing argument. Depending, if the defense, if we do put on any evidence, so if we offer witnesses or we actually defend ourselves, at that point we lose the advantage of being the last voice heard in closing. So we're the first voice heard. We give our closing arguments, and then the state gets to rebut and give a closing argument, and then the case closes and the jury decides. If we do not put on evidence, then the state now has to go first in closing, and we get to be the last voices heard because we didn't put on any evidence. So there is a strategic advantage if that works. Sometimes that's not really an advantage if you got good exculpatory evidence and people need to put that evidence on. Chapter 8 is kind of an extension of Chapter 7, talking about pretrial procedures and the trial process. Talk about plea bargaining. 95+% of cases that go through court are not decided via trial. They're plea bargains. Usually there's some type of plea deal reached where we can get rid of this case without it clogging the trial process, and we can let's take care of this case without it going there. Let's see if we can agree to something, or see what I can get my client to agree to, see what the DA can agree to, and we all go home with as much of our shirts on as our clothes on as possible. We don't get ripped off. So that's what the plea bargaining process is. There are usually not a lot of rules. There are rules involved, but a lot of times I got cases going on now where I have my own investigations going. I have experts that my client has to pay for and hire out to get to the bottom of evidence and investigate stuff, because we want to find that exculpatory evidence. If we can find something that help, one thing, all I need is one big thing that says either my client was justified in what he or she did, or they didn't do it at all. And if I can get that before trial and bring that to the DA and say, here, drop it on the desk, look at this. This shows that my client didn't do it or that they were justified. So we'll give you time to look at it, then let's talk about dismissing the case, or let's make a deal where my client just does community service or something, come in return for a dismissal. So we get to use all that. Exculpatory evidence, sometimes my client's record can be used in mitigation, meaning not my client's record, my client's lack of a record. This person's never been in trouble before, and now they're all of a sudden in court. I can use that, like, hey, this person's a first offender. Let's see what we can do about disposing this case without it going all the way to trial. So that's kind of the process. It's essentially a bargaining process. In bargaining, you're using leverage. I do more bargaining than pretty much anything else that I do in my law practice. I'm a criminal defense attorney, and I like for my client. I am a trial attorney by trade. I don't mind it. I know how to do it. I do it. But I really feel best when I'm able to get my client out of there without going through that risk. So if I'm able to walk my client out of that courthouse, and my client was able to control the outcome, that's what I love. Not only does it save time, but I'm the type of person, I like winning, right? But I really like winning when I didn't have to go to trial to do it. Now, if I go to trial and get a dub, cool, awesome. But my client still wasted resources. There's still money involved, and they're still sweating bullets. Sometimes that peace of mind from controlling the outcome is way more valuable than going to trial and sweating bullets, not knowing what that jury is going to do in that back room, what they're going to come back out with. There's a lot that goes against one's sanity when that happens. So you don't know. And even when you win, it's like, wow, I still lost my mind. So I like to try to negotiate as much as possible and leverage and use things. That's chapter 8. Chapter 9, sentencing goals and structures. We talked about the purposes and functions of sentencing or punishment. Of course, we want just desserts or retribution. Someone does wrong, it's kind of the eye for eye thing. You did wrong, you're guilty now, we got to punish you. Sometimes that punishment may involve incapacitation. We got to take you up out of here. We got to put you in permanent timeout for life, or if what you did was so heinous and aggravated, we may even have to sentence you to death. Then there are also other purposes like rehabilitation, not just restoring the victim and making the victim whole through restitution, but sometimes a person commits a crime not because they're a bad person, but because they feel like because of their situation they had to do it out of necessity. I'm a hungry mother of five, single mother of five. I don't have any income. I went to the grocery store to steal that bread so my kids could eat. Sometimes in their punishment, it's not necessarily about beating them over the head or making an example, but it's about saying, hey, maybe if we can give this person a means of of uh, living differently and helping them learn life skills so they won't have to repeat that course of conduct, um, then that can keep them from being a recidivist. So we can help them. We can keep the criminal justice. We can help the criminal justice system by helping this defendant. So and and also another purpose is deterrence. That's why trials and sentences are public things, because we want to show the society that, hey, if you do this, this is what can happen to you. So not only does it punish the person that commits the crime and it deters them from doing it in the future, but it also deters all those that are looking and say, hey, I don't want to be like that person. Talked about determinate and indeterminate sentencing. Indeterminate sentencing is when you're sentenced in a range. There's a maximum, and there's a minimum and a maximum, and you're going to get out of jail at least after you serve the minimum, or it can be anywhere up to the maximum, or something can be added on to it. That's what we call indeterminate sentencing. Determinate sentencing, usually in North Carolina in our district court system, is usually determinate. It is determinate. So you get sentenced to an exact amount of days. So for a certain misdemeanor, it may be 20 days. If you get sent to jail, after that 20th day, you get out. On that 20th day, you get out. It's determinate. We know exactly how much time you're going to be in. So that's indeterminate versus determinate. We also have structured sentencing guidelines, and we'll transition to chapter 10 now, where we talk about the fact that sentencing is structured because America has this thing called racism, and it has this thing called bias, and that has been a part of sentencing forever. So probably during the middle part of the 20th century, I'll say later part of the 20th century, maybe after 1960s, 70s, we started having structured sentencing, where now these judges can't sentence anyone that much differently based upon a bias than they would someone else. So structured sentencing makes court predictable, and I can look at my client and say, "Hey, this is your criminal record. This is what you're charged with." We look on a sheet of paper. Depending on where they intersect, this is where you're going to be sentenced. So we can determine it's pretty predictable. We know what's going to happen. So that's structured sentencing. Then you have different types of sentences. You have active incarceration, where you go to jail. You also have probation. Probation is when you're in jail. You're like the Walking Dead. You're walking around with a suspended sentence, and that's how the judge says it. This sentence is suspended because you have a punishment suspended above your head, and if you don't comply with certain demands, do this, do that, show up to your probation office, have clean urine test, go get a job, do this, do that, take this counseling, and complete this counseling. If you don't do that, then we can bring you back to court, and we can cut that invisible cord and drop that suspended sentence on your head. So you're in jail. You're just not physically in jail. You actually still have a DAC number when you're on probation. So that's probation. Sometimes they have what they call shock probation or split sentencing, where part of your sentence you actually do some active time, but you get out with the remainder of that active time hanging over your head, and you're still on probation. That's what we call shock sentencing. Then we talked about death penalty and bifurcated trials. So usually in a capital trial, there's the trial itself to determine guilt or innocence, and then there's almost a separate trial to determine whether this person is going to be sentenced to death or not. Of course, the victim has rights as well, not necessarily constitutional rights, but they do have a right to be heard once a person is convicted, and that's either by plea or by being convicted at trial. The victim has a right to be heard if they've been out of something. Of course, this person stole my TVs. I want the value back, or they killed my relative. I deserve to be in court and to say how I feel about it and be heard at sentencing. Usually that's done through victim's impact statement or the victim just physically being there. Chapter 11. We talked about the juvenile justice system, how it is part of the justice system, but it has a separate naming and a separate language. So the trials are the same, everything's the same, it's just called something different. We talked about parents' patriae, which is the essentially the right of the government to be a parent to the people, especially to the kids. That's almost like the duty of the government to take care of those who can't take care of themselves. Talked about juvenile court, juvenile history, what a juvenile delinquent is. A juvenile delinquent is not a runaway. A juvenile delinquent is a juvenile, someone below the age of majority, depending on what the jurisdiction is, that has been accused of a crime that would be a crime if an adult was accused. So essentially, you're not a juvenile delinquent until you're accused. You're a juvenile that's accused of committing a crime. So then you have the juvenile court system, the adjudication, disposition process. They go through court, same burden of proof, just like everybody, just like other people. Same burden of proof, so they have trials as well. In certain situations, they can be tried as adults. It just depends. So we talked about that. You have differing types of sentencing. You have like inclusive and exclusive blends, where sometimes they can be sentenced part of their sentences. If it's exclusive, it's either or. If it's inclusive, maybe part of their sentence may be served juvenile. They turn a certain age and they go to adult prison, or either some type of combination. Where usually when we talk about exclusive blends, whether it's juvenile or adult exclusive, it's either or. The court has a choice. Either you're going to sentence them here, or sentence them there, but it won't be both. Chapter 13, we talked about diversion. Those like our first offender programs, alternative dispute resolutions. That's another way during the plea bargaining process. If we can come to an ADR decision, a dispute, alternative dispute resolution, or diversion agreement, that can keep the case from going to trial. That allows me that saves the court time, and it allows my client to control the outcome. So in other words, go do this community service, go finish this program, come back, and the DA will dismiss it without you ever having to go to trial. So you even have specialty courts like drug courts. Those are courts that assist people in trying to, because some people commit crimes the crime itself may not be drug related, but why they committed the crime is definitely drug related, and this person may need help. So you have drug courts to help keep these people accountable. Of course, they have time hanging over their head, so that's more of an incentive. You have domestic violence courts, which can sometimes be the same way, where just one subject matter being heard in this court. You have youth courts, or mental health courts, the same thing, to kind of hold this person that may have a mental health ailment accountable and keep them on their medical med management. Then Chapter 14, courts, the media, and the litigation explosion. We essentially talked about how the media is in the courtroom now. Everything is televised, and that also blew up the lawsuit explosion. Everyone's suing everybody now. And that brings into question what we call tort reform. A tort is what we call a civil wrong. Some torts are also criminal. Some criminal actions can also be sued for in civil court. So that's what happened to OJ. So he won the criminal trial, but then the family sued him for the tort of wrongful death. And they won. So even though he won the criminal trial, he was free. He still wasn't financially free because he had to pay them money. There was a judgment rendered against him. And remember what we said back from like chapter 2. There's a difference between the burden of proof in criminal court, which is very high, hard to prove guilt, versus civil court, which is very low, easy to prove guilt because it's now by preponderance of evidence. So it was easy to prove that he was civilly liable for the wrongful death of those two people than it was to prove that he was criminally guilty of the death. So the O.J. Simpson case is just an example of how both criminal and civil court can work at the same time in the same cases. So tort reform, when we have medical malpractice, a lot of times because these lawsuit judgments are so high, the cost gets passed on to the insurance company and to us. So they want to kind of put limits on what these people can get from these medical malpractice claims, because if we don't put limits, it's going to drive up insurance. So that's tort reform. That is it for the semester. I just went through chapters 1 through 14. Once again, do remember that my my lectures are actually a supplement to your reading. It's your job to read. I give a lecture only to supplement. I can't sit here and read everything for you. I can talk about the subject matter, answer any questions you have, but it's your duty to read. So the exam is going to be 40 questions. It's going to be totally cumulative, so it's going to cover everything through the whole semester. Going to be a lot of repeat questions from the midterm, which is going to make it cumulative. So you're going to have repeat questions from chapter 1 through like chapter 7 or 8, wherever we stop. I think chapter 9. It's also going to include questions from the chapters after the midterm. So it's going to be cumulative. I promise you, these questions are straight from the book. Literally, I had to create my own questions for this class. So literally, I created the questions straight from the book. So if you've listened to my lectures, you should be fine. And if you have read the book, skimmed the chapters, at least tried, you should have enough of a knowledge base to answer these questions. Once again, it is going to be the test is going to be online. Of course, because it's an online test, I'm not using the test proctor software. So honestly, it is essentially an open book test. Now the test is limited in time. You're gonna have 3 hours to answer 40 questions and an additional extra credit question, so 41 questions total. So you gotta think you can answer 40 questions easily in that amount of time if you know what you're talking about. But if you're flipping back and forth to the book trying to find an answer, you can do that, but it's definitely going to take time out of that's going to have you taking the test longer. I think even doing that, as long as you don't do it for every question, I think you should be fine regardless. But I just want to make sure you're able to find the knowledge in the book and you have an understanding of what I taught you this semester. So good luck. It was a pleasure teaching you guys this semester. And let me tell you more about the exam. Like I said, 40 questions. Each question is worth 1 point towards your final grade, so the total exam is 40% of your final grade. And there's an additional extra credit question that can give you an additional 5 points that could boost your points, or it could help supplement maybe something you missed. You get 5 points for having the book. Some of you never got the textbook. So if you get a perfect 40 plus the 5 points for the extra credit question, that 5 points now gets absorbed throughout the whole semester. So that now can fill in for something you missed or something else that you didn't get a perfect grade on. So that's how I do the grading. So I'm thinking what I'm going to do is go ahead and post the exam tonight, and I'll let it be up all week. So once it's going to be up all week, so you essentially have most of the week to take it. You can reach me via email if you have any questions. Now the exam, you're going to have 3 hours to take it, 40 questions. You have to take it in one sitting. So once you sit down and you open it, you got to take it right then. You can't close it and then come back and finish. You got to do it in one sitting. If you have any technical difficulties, just either text me and I'll give you my number and email address and the link. Text me or email me, and I'll reset your attempt. Sometimes and when you guys are taking an exam, your computer something may happen, or something may happen to your internet, and you may have to log back in, and I can reset it for you. Also, try to do it in a reliable internet with internet engine. Like I usually use Chrome or Firefox. Chrome's probably best, so that will limit the possibility of you needing to have me reset the test. So the better the internet engine you use, the less likely you are to have to or to run into technical difficulties. So I think that's about it. If you do have any questions, you know how to reach me via email, or you have my cell phone where you can text me, and I'm willing to answer any questions. But you guys be good. It's a pleasure teaching you guys this semester. I know these are weird times, right? But I want you guys to be tough, focused. You probably have been asked to do something different than any other a group of students in across college, across the time of college, the class of 2019 didn't have to do this, right? They already graduated, but you guys are the class of 2020, or you guys are college students in college in 2020. This is a weird year, but I want you guys to soak it in, adjust, try your hardest. Please don't collapse, don't break down. It's hard for all of us. I'm used to being in front of you guys teaching. I'm at a computer, teaching this class, and posting YouTube videos, right? That's not how I'm used to teaching this class. So I had to adjust as a teacher. You guys now have to adjust as students. I know you may have to holler and say, "Oh my God, I can't believe this is happening." That's fine to do that, but don't do it for long. Bring it back in and get the work done. We've had to adjust. We've even had to adjust the assignments. I adjusted this semester. Of course, we couldn't do group work, so I had to create a discussion board, right? We found a way to get it done. So find a way to get it done. And that's for all your professors. I can't determine how they're going to grade you or how they are, but I know what I can do. But the only thing you can control is your effort. Stay online. Check your email. You can still reach us via email. That's me or any other professor, and stay engaged. Don't give up. So this semester is not a wrap. You guys can get this done, and I believe in you guys. So Aggie Pride.